all Kenyans of goodwill and of your patience and understanding and support that you give to accountability and good governance. As you are aware, there is a petition before Department of Finance, Departmental Committee of Finance, Trade and Planning for my removal from office. In light of the allegations forming basis for petition in question, I wish to just share with you, through you and to the Kenyans, my side of response to these allegations. Let me emphasize at outset that I have nothing to hide and would wish that the truth of this allegation can be unearthed fully. My concern is really on the fairness of the process involved and in considering the petition against the settled principles of natural justice, which my lawyer, Mr. Molo, may expand on later. So let me reiterate, I'm not here to fight any arm of the government or anything. I'm here just to say my side of concern about the fairness, but also to go through the allegations so that this message may go to the Kenyans. They can understand my side of response to each of the allegations which were made, which were pertinent to my removal. Now, I would like, first of all, before I go to the specific allegations, to respond to this issue of natural justice. And I think there can be no other person best placed to explain my concern about the process so far of this petition. And I would like, if you allow me, ladies and gentlemen, to invite Lawyer Otiende Amolo to just explain my concern in very precise mode. Then, after that, I want now to dwell into specifics of the petition which was brought in by Mr. Magona, point by point to the extent possible. Just move this.
Ladies and gentlemen, good morning once again. My name is Otiende Amolo. There are two aspects to this. There's the question that there's an allegations against the Auditor General, and there are 7 of them, and he will respond specifically to each of them. But the question has been asked that why did the Auditor General have to go to court? And there's also probably a legitimate question you will ask, that why is he responding to these allegations to you rather than in Parliament? And I think an explanation is owed in that respect. But it is important to start by pointing out that the Auditor General did not rush to court when he received the petition and invitation by Parliament. He could have done that, but he chose to comply with Parliament's request. He duly attended Parliament, he filed a response with Parliament, but filed certain concerns with Parliament through various letters which will also be shared with you, because there were certain fundamental issues that suggested that the process that he was being put through was not fair. And he thought, and we advised him, that the best forum to raise those issues was before the committee itself. All the issues that have now been taken to court are issues that were raised before the committee, all of them. The committee chose not to respond to them. There are many issues, there are over 30, but we'll only give you 10 so that you get a synopsis of why the Auditor General is saying that the process that Parliament is taking is not fair. And if the process is not fair, it cannot result in a fair outcome. Number one is the question of fast-tracking. You all know that there are many petitions that have been filed with Parliament for removal of constitutional office holders. None of them has ever been fast-tracked to the extent of being finalized within 1 day. It is only the case of the Auditor General that was considered by the clerk on 14th of February, considered by a committee of lawyers called the advisory committees on 14th of February, considered by the Speaker on 14th of February, and then committed to the National Assembly. That is unbelievable fast-tracking, considering that the law allows the clerk 7 days. When the Auditor General saw that, he raised that as a legitimate concern before the committee. The committee did not think there was anything about that. It should be pointed out that on the same day that Parliament was now dealing with that question, on 16th of February, Parliament itself posted to the newspapers invitations for memorandum on submissions on why the Auditor General should be removed. You will also realize that that advert came out on 17th of February, which means as Parliament was considering that matter on the floor, it had already been decided that it would be approved, and therefore it was posted for invitation. That is a question of fairness. The second fundamental question, which was raised before the committee, is that there is a person called Mwagona who went as the petitioner to remove the Auditor General. When then he appeared before the committee, he said he was not the petitioner, he was merely the lawyer for the petitioner. So we raised with the committee that could we then know, could the Auditor General know whose real accuser is? Because anyone can petition for your removal, but at least you're entitled to know who is the real petitioner. We have a situation where there's a mystery petitioner. The committee refused to think that that was a real issue. To date, we do not know, and the Auditor General does not know, who the real petitioner is. As a matter of natural justice, you must always know who your accuser is. You must know whether it's a member of Parliament, whether it could be any of the officials in Parliament, whether it could be any of the people you have audited adversely, because then you can judge the good faith element. The third issue is that the petitioner brought the petition. In his petition he says he's one of the petitioners. So we asked the committee to ask him, who are the other petitioners? Because clearly it meant they were acting in collusion. The committee has to date refused to ask him who the other co-petitioners are. Only if you know who else is with the petitioner can you know what the real motivation is. The fourth issue, which is equally fundamental, is that the Constitution in Article 251 is very clear. Any state officer can be removed from office for gross violation of the Constitution, serious violation of the Constitution, or gross misconduct. But for the committee or Parliament to consider that petition, the person petitioning must start by claiming that you have committed a serious violation or you have committed gross misconduct. The Court of Appeal in the Wambora case was very clear on that, and the laws and Parliament itself, through a communication by the Speaker, gave guidance on that issue. And the Speaker of Parliament, Honorable Justin Muturi, directed that before such a petition is considered, there must be an allegation that there's been a serious violation of the Constitution or gross misconduct. In this case, forget about the proof, there is no allegation. And so the Auditor General asked the committee whether they can consider a petition when the basis of such a consideration has not been laid. The committee did not think that was an issue. Moving forward on that issue, it is important to note that the Auditor General is facing a petition for removal from office on the basis of allegations. The petitioner did not annex a single document in evidence with the petition, not one page. And so when we appeared before the committee, we asked them, can the petitioner give us any evidence, whether documentary or otherwise, on the basis of which the Auditor General can respond? The committee said it was not necessary. But in the course of the proceedings, they then found it necessary to ask the petitioner to bring the evidence. So what happened is that on the 28th of February, they adjourned the sittings and asked the petitioner to come the next day at midday to bring the evidence. They directed the petitioner. On the next day, the petitioner wrote saying he will not provide the evidence, that it is up to the committee to find the evidence. Now, if a petitioner has been directed to give the evidence he has, but he says he has it, but his client has refused to allow him to disclose, ordinarily in natural justice, that must be the end of that petition, because you are the one who has petitioned. The committee then decided that although the petitioner had refused to give what he had, it was now the obligation of Mr. Ouko to give the evidence to incriminate him by directing him to go and get all sorts of evidence. That does not happen anywhere. Whoever alleges must prove. And if there is no proof, or you are not willing to prove, then that is the end of your case. We are in a situation where, to date, the petitioner has not provided a single document in evidence. Instead, what is now happening is that the committee itself has become the accuser. It is the committee that is asking everyone else, might you have anything against the Auditor General, summoning people, as if it is the committee that initiated the petition. That is against natural justice. That is against fair administrative justice. The other violation is this. Usually in law, if you are accusing someone, you are allowed to say what you are accusing them of. And once you are done, then the person you are accusing is asked to respond. The petition here has 39 paragraphs. The petitioner only went up to paragraph 15. Then he was asked to go and bring evidence before he can continue. But strangely, that same day, before he could be allowed to bring the evidence the next day, that same day the committee then invites Ouko to respond to the whole petition. How do you respond to a petition that has not been presented in full? We raised that with the committee. The committee said, no, give your response. Mr. Ouko therefore began to give his response. He gave his response up to 8 p.m. but he only got up to paragraph 7 of his response, which was up to paragraph 16. Then he was told, now it is late, you can leave, we will decide whether to call you back or not. That means he was being asked to respond to an incomplete petition. That is against natural justice. More interestingly, and this is the 7th point, when you are asked to give evidence, usually even in Parliament, and when it is critical, you will be sworn in. You will all remember the issue when the former IBC commissioners, especially the chair, the drama around being sworn in. But it is parliamentary practice that you are sworn in so that what you say on oath. If it is a lie, then it can be dealt with. This is a petitioner who was allowed to make very fundamental and scathing allegations against Mr. Ouko without being sworn in. We raised that with the committee. The committee decided that it is not necessary to swear him in. Now, if you are not sworn in, then whether what you say is true or not is a matter of conjecture. But at least there's usually one cushion, that then the person you're accusing should be allowed to ask you questions. We asked to be allowed to ask the petitioner questions. The committee refused. So you are being accused without evidence. The person accusing you is not giving evidence or not. You are not allowed to ask him questions. How fair can that process be? The other very interesting thing is that the only notification Mr. Ouko ever got was the one inviting him on the day he was to give evidence. He is completely unaware of who else is to give evidence on what date, and therefore does not have the opportunity or right to be present when he's being accused, does not have the opportunity or right to even ask questions to whoever else is going to give evidence. More fundamentally are two very important questions. The issues that are before the committee, by the petitioner's own admission, he stated that he had taken them to the EACC, he had taken them to the DPP, and he had taken them to the court. But he was not satisfied with the way it was dealt with. What does that mean? That the DPP found there was no evidence to incriminate Mr. Ouko. This petitioner was not satisfied, so he goes to court. So we asked the committee that before you hear this issue, can you make a decision whether you are entitled to sit on appeal on a decision by the DPP If your answer is yes, then fine, you can proceed. But if your answer is no, then you cannot proceed. The committee refused to do that. The law is very clear. If you are dissatisfied with the decision of the DPP, you go to the High Court to review that decision. You cannot appeal the decision of the DPP by going to Parliament. The last point, and this is fundamental, is the question of sub judice. The petitioner states, and is on record, that he took these very matters to court and that there's a case pending in court. Ordinarily, the rule of sub judice applies that if then there's a matter that is actively in court, and on the basis of mutuality of respect, Parliament will not deal with it. Just the way ordinarily, if a matter is pending before Parliament, ordinarily, the court will not deal with it. We raised that matter, but the committee decided that it did not matter that there was a pending court case. There are actually two pending court cases, the specifics of which we gave to the committee, and they are all on the same issues brought to the committee. Interestingly now, when now the matter is in court, and the question of sub judice arises, now the committee says the court should not have dealt with the matter that is before us. But the matter was before the court before it went to Parliament. It's very important to understand that. So if there was a question of mutual respect between the arms of government, Parliament should not have dealt with the matter in the first place. Let me explain three quick things and then we come to the specifics. One, is it true that the court ought not to interfere with anything that Parliament is doing? The answer is yes, but only when Parliament is exercising its legislative mandate, lawmaking. Ordinarily then the court will wait until the law is made and then anybody can challenge its constitutionality. But in this case, Parliament is not making law. Parliament is acting as a quasi-judicial tribunal, and this is very important. When Parliament is acting as a quasi-judicial tribunal, and that is the case, for example, if it comes to impeachment of the president, or removal or impeachment of a governor, or removal of office of the Auditor General, Parliament or the parliamentary committee is not making law. It is acting as a tribunal, an investigative tribunal. When it does that, it is inferior to the High Court, and the High Court can interfere with it at any time, which is why Parliament was able to overrule the Senate on the question of removal of Governor Wambora, which is why the judiciary has been able to interfere even when Parliament made a decision to remove the commissioners of the Judicial Service Commission. You will remember that the courts were able to quash that decision. Anytime they are acting as a quasi-judicial body, then Parliament cannot say we are immune from the courts. The second very fundamental point to make is that the law that guides Parliament on that issue is not the standing orders, but the committee insists it is. It is the Constitution, and it is what we call the Fair Administrative Action Act. Parliament itself last year passed a legislation to this effect, and I invite you to look at it. The Fair Administrative Action Act says that anytime anybody sees as a quasi-judicial body, anybody, then the law to guide it is the Fair Administrative Action Act. Under that act, there are certain things that must be done. This very Parliament passed that law. When then we invite them to follow that law, then they say no, we will not follow that law, we will follow the standing orders. That law entitles anyone who is aggrieved to go to the High Court. So the National Assembly itself has passed a legislation that says if its committee sitting as a quasi-judicial body does something improper, then you are entitled to go to court, including against that committee. That is the law that they have passed. When then Mr. Ouko invokes that law, then they say you should not have gone to court. But they are the ones who passed the law. So the overall situation here is we are in a situation where Okiya Omtata went to court by himself and has obtained orders stopping the process. Because of the concerns we have summarized, Mr. Ouko also went to court and got orders stopping the process. The orders we have in court stops the committee from continuing with the hearings, stops the committee from receiving evidence, stops the committee from making a report to the National Assembly, stops the National Assembly from debating that report, and if they debate it, it stops them from submitting a recommendation to the President. But if they decide to do that, it stops the President from constituting a tribunal to investigate the matter. What does that mean? It means that if the National Assembly decides to ignore the court order, then it would proceed with the hearings, but everything it does will be null and void. Because at the end of it, the court then will declare that the process had been stopped, and every effort, every money, every time will have been wasted. It's a situation which would otherwise be avoided if Parliament respected the court order, or respects the court order. The National Assembly itself is represented in court by competent lawyers, and if it thought either that the court do not have that jurisdiction or that order is unfair, then the proper thing is for the National Assembly's lawyers to either appeal those decisions or to apply to set them aside and to make all those arguments in court. If we were to have a situation where we are to proceed despite the court orders, obviously it would result in a very sad situation. So I think we pointed out to you just 10 of the about 30 reasons that led the Auditor General to go to court to stop the process. It is important to note that the Auditor General that has not gone to court to stop the process so that he does not answer. He has gone to court to ask that, can this process be conducted in a fair manner so that as I respond, it is fair to my rights, to my situation. It is only on that account that he has gone to court. And it is for that reason that we advised him that because of the court orders, he can no longer appear before the committee, because that will be in contempt of court. But if the orders are lifted, if they are valid, then he will appear before the committee and still give those very responses. So although he's not appearing before the committee, the Auditor General has still taken the additional step, because of accountability to Kenyans, to answer anyway, the way he would have answered if the process was fair, or if they were to restart a process that is fair. I think that's the situation. Thank you very much.
Thank you very much, lawyer. And from that, I am prepared. And what I'm going to tell you here will also be shared and sent to the National Assembly. Now, what, in my view, irrespective of what has been said by the lawyer, I think we are embarking on a precedence. We must protect the offices. We must see how they are handled or taken out of the office. Now, let me go, and if you allow me, I will read the petitioner's concern and then my response. Now, the first petitioner concern was that failure to submit report to the President and Parliament pursuant to Article 2541 of the Constitution. It is my position that the Auditor General has dutifully submitted audit reports to Parliament in discharge of the mandate which is enshrined in 229. There is no provision specifically that I provide this audit report to the President. But as for the financial report of my office, which is the audited report of my office, these have been going to Parliament after the audit of my office, and therein are other information apart from financial report of my office. Second, wastage of public funds. The petitioner alleges that contrary to Article 201D, the Auditor General has wasted public funds by running an iPad charges telephone in excess of 1 million. This is not true. The amount captured in the petitioner and the amounts captured in my telephone bill or in the accounts of my department does not reflect this 1 million. And therefore, I really don't know where the petitioner got the 1 million, and we had asked that he provides us with more details, and we will respond further if he can provide more details of where he found the 1 million. The petitioner alleges wastage of funds wastage in the use of vehicles allocated to the Auditor General. I wish to categorically state that I have only 2 vehicles allocated to me and not 5 as alleged. Further, none of my family members is allocated a vehicle. See, the other allegation that the auditors wasted public funds by leasing office space in Mombasa for Kenya shillings 10 million when the premises remained unoccupied or unused in a way by the office for a period of over a year. Generally, issues of leases and acquisition of premises and goods and services fall under the Department of Corporate Services, which is headed by a Deputy Auditor General in charge of corporate services. However, for the citizens of Kenya, I would like to state, as the accounting officer, I am aware that the office entered into a lease agreement with a company called Baywood Holdings Limited for a period of 6 years. While in the process of procuring the partitioning of that office, the Bima House, Mombasa, where part of my staff were housed, offered extra space at no cost. We immediately accepted, and it became necessary to terminate the Baywood Holdings lease at a cost of 10 million. This action therefore saved the taxpayer the 10 million, or in total, if we were to be there 6 years, 43,752,000, which could have been paid for the remainder of the 5 years lease period. The other allegation is that the petitioner alleged that the Auditor General, contrary to Article 201D of the Constitution, initiated a project for partitioning the head office, this where we are right now, and paid 25 million. Yet no partitioning was ever done, and therefore public funds were used to pay for services not provided. Again, as the other one, these are a domain of the corporate services. However, the intention of commencing, I must explain this, the intention of commencing partitioning project was to convert these offices you see here and these spaces you see here into what you call open space plan, due to a number of staff which were coming on board at that time. The firm contracted to design the project, Shelter Crafts Limited, was procured following the normal procurement process, and every procurement process was followed in the procurement of Shelter. In the course of the performance of this project, the office received a funding from the Treasury for the purchase of land for construction of what you'd call the OAG offices at Bishop's Road, Upper Hill. In the light of this development, the office proceeded to terminate the contract with Shelter Craft Limited, who were then paid an amount of 3,463,185,000 Kenya shillings. That design work was not undertaken, and the 25 million, as alleged by the petitioner, was never paid. Further, contrary to Article 201D of the Constitution, the Auditor General procured audit vault software at an inflated cost of Kenya shillings over 100 million, and I personally authorized payment of Kenya shillings 100,675,680. After it's alleged all officers in command chain refused to approve the voucher on grounds of insufficient procurement documentation. As you are well aware, this matter has been the subject of the EACC investigation for over 36 months, basically over 3 years. and which has culminated in a report of the DPP of 3rd February 2017, which exonerated me from any wrongdoing. The EACC, in their appearance before the committee that is considering this petition, alluded to the fact that they were still investigating the matter in furtherance to the DPP recommendations, and I cannot therefore say much on this or purport to answer for those staff who were involved or those who were found culpable. As for the figure which is being branded of 18 million to be the value of this software, and it is not a software, what we are introducing was a system, and this 18 million was to include the software installation, purchase, and so forth, and implementation. This cash shilling, which was the cost, the total cost of 100,675,680, and this cost included the software, there were business intelligence tools, and the implementation, including some element of training. Now, why was I concerned or about this audit vault and the system? This system was to facilitate my office to be able to, in a real-time manner, see the transactions which are going through IFMIS. And as you know, IFMIS is where the platform which all the accounting for national as well as county accounts are done. And therefore, this would allow me to detect any malpractice within the national and county governments. It has been alleged that I personally authorized payment for the purchase of vault without formal contracting in place. Yes, an LPO was issued before the contract, but payment was made after contract signing. As would be expected, I signed vouchers of amounts exceeding certain limits, such as the payment of the audit vault, but only after other signatories, and this can be verified from the vouchers. The amount about the money trail unveiled by the EACC and reported to have emanated from the payment to a company known as OC Kenya towards the purchase of the software, I wish to state that EACC has confirmed that there was no connection or link whatsoever to me as having benefited in any way from the proceeds of that transaction. However, the petitioner further alleges that of the 100 million paid to OC, that we must mark this, Kenya USD 361,300.25 US dollars was subsequently paid by OC Kenya to a company known as Weston Africa UK, a firm associated with the Auditor General through a Mr. Ochieng Oduol, and further stating that the Auditor General benefited from award of the contract to OC Kenya, and therefore allowed personal interest to conflict his official duties as the Auditor General and Accounting Officer. I categorically state I have not benefited from award of contract to OC Kenya as is alleged. Through a separate legal process, I have sought and have asked my lawyers to seek remedies in law against Mr. Mwagona for this malicious and false and reckless utterances, and I wish he had sworn his statement in Parliament. The petitioner further alleges